Hello and welcome to the big picture. The decision of the Supreme Court to direct the government to hand over the entire list of foreign bank account holders in its custody has raised concerns and questions about the issue of treaties and the role of the executive and judiciary. All this while the government had been arguing that the lists can't be given as it may breach the confidentiality clause of the various agreements and treaties with other countries, it acceded to the direction of the court. Though the Apex Court today said it would not reveal the names of the account holders and directed the SIT appointed by it to pursue the matter, several questions still remain. We will discuss today these issues with an eminent panel of guests. I have with me Soli Sorabjee, former Attorney General of India, CM Vasudev, former Finance Secretary, Government of India, and Mohan Guruswamy, Economist and Chairman, Center for Policy Alternatives. Welcome to all of you. Mr. Sorabjee, there are still after what has happened today, the court has taken custody of all these names of 620 odd people. There are still some concerns being expressed that, this may have problems as far as the future treaties with other governments are concerned, as far as double tax avoidance and things like that. You think those concerns are valid, or you think that we need not be worried so much?
No. Once you entered into a treaty, you got to carry out the treaty obligations. Those concerns are certainly valid. Because then, look at one side of the picture. Apart from the legality, I don't know whether any court can issue a direction or a mandamus which requires the other party to act in breach of the law. Yet it will be in breach of the treaty. The question is, if you do that, you won't get information from the banks. They won't cooperate.
Exactly.
Then what will you do? Legality apart. But the only good saving grace is that the Supreme Court has not opened the envelopes which were handed over by the Government of India containing the names of all the account holders. And it has been very clear in his observations that they will not reveal the names.
Mr.
And it has given it to SIT.
Mr. Sorabjee,
but actually,
sorry.
It's a complex issue. I don't know how it can be done.
Mr. Sorabjee, sorry to intervene here.
Yes, go on.
My question is this. It is good that today, when a lot of people are relieved that the Supreme Court has said that they're not going to reveal the names. But what happens to those names which have already been revealed? There were 7 people whose names were relieved, and an entity, their names were revealed. Before that, in April this year, when the UPA government was there, they revealed some names of people. So now these 627 are now in a different category, and all those people whose names have already been revealed, would they not feel, that they have been discriminated against?
No, it depends. The names which have been revealed, was a prosecution initiated against them? Was investigation done? Then in that case, there is no question. Then you can reveal the names. The only question is, don't reveal the names of all, because don't assume all people have tainted accounts. Some people have accounts which have been opened in accordance with law, in accordance with the current regulations. So to that extent, you are right. The people may feel not discriminated against, but being given a different treatment.
Absolutely.
But the whole thing is, please understand, this is an extraordinary order of the Supreme Court, and I think it will raise many questions about other countries' willingness to enter into treaties with us. The net practical result will be we won't get information. Information will dry up if you are not going to carry out the obligation of confidentiality.
But coming from a person of view that, this is an extraordinary order is very, very serious. Let me get, we are joined in now by Mr. Shashank, former Foreign Secretary, Government of India. Mr. Shashank, do you share the concern of Mr. Sorabjee as far as this issue is concerned, what he has been saying?
Well, what I would say is that generally under the law of treaties, the governments willingly agree and enter into international treaties with the obligations being kept in mind, and most of them are then incorporated within the local laws so that they become part of the local laws also. Now what happens that there are certain countries, including the United States, which feel that their own courts have the highest jurisdiction and the treaties are subservient to them to the extent that unless the courts agree, they will not be fully implemented. Secondly, in the case of countries like India, the treaties are ratified by a decision of the cabinet.
Right.
In countries like the United States, they have to go to a verification and approval by the Congress,
Right.
and only then the treaties are entered into. Even then, the courts, the Supreme Court of the United States retains the right to ask the government to go according to the requirements of the US laws, and the treaty obligations then are considered to be subservient to the US laws.
Right. Okay, that's very interesting. I would like Mr. Sorabjee to react to that before I go to Mr. Vasudev. Mr. Sorabjee, how would you react to that? You know, if you take the US laws, all other treaties and things are subservient to their own laws. As far as India is concerned, doesn't that apply?
Well, I don't know about the US court judgment. I'm not aware of it. But the fact of the matter is you have solemnly entered into a treaty obligation. That's the legal obligation. And I don't think how that can be overridden by other considerations.
Okay.
How do you override that? How do you breach it? You solemnly entered, willingly entered, voluntarily entered.
Okay, let me get Mr. Vasudev in on this. Mr. Vasudev, do you think that the Supreme Court's decision order, and the government giving these documents to the Supreme Court with the names, is there some kind of a problem there? Is it a breach of confidentiality? Do you see a breach of confidentiality clause? Do you see problems in the future if India approaches other governments for this kind of information?
I think no government of any country will enter into an international treaty which has provisions which are repugnant to their domestic laws. I think this is a very basic premise that one should start from.
Okay.
And there is no reason to believe that the treaties in question that we are discussing today, they are in no way repugnant to the Indian laws. And of course, if any treaty, any provision of a treaty is repugnant to the domestic laws, then the courts have every reason to interfere. But that is not the case in this matter. But I think the provision regarding the secrecy in the treaty is stemming from the banking secrecy laws which are prevailing in every country and the other country with whom we are talking about this treaty. And under these banking secrecy laws, there is a secrecy between the account holder and the bank. And that secrecy can be violated only when there are legal requirements, when there is a case going on, or where there is a case of ill-gotten wealth having put into that account. So only in those cases can the secrecy clause be violated. And in this particular case also, I think the treaty that we are talking about really stems from the same premise that in case those account holders are found to have accumulated or deposited money which is ill-gotten wealth, then it can be released. But then that is a question of investigation. And that is, I think, exactly the stance which the government had taken, that they will be able to release the names of those people against whom some prima facie case is found of violation of any law.
Right.
But here to release the names wholesale, I think seems to be quite repugnant to the provisions of the treaty. And I think Supreme Court in its own wisdom has perhaps rightly said that they will not be releasing the name. In fact, they will not be opening the sealed envelope in which these names are there, and these sealed envelopes have been handed over to the high-powered SIT, I think, which is a good saving grace, as Mr. Sorabjee said. But I think I want to make a slightly general point also.
Okay.
Just one slightly general point. That, in any legal system, if the highest court of the land exercises original jurisdiction with regard to supervision of investigation and exercises original jurisdiction legal matters, then there is no way the aggrieved party even has one right to appeal. That is an issue, I think, which our legal luminaries must try to debate, whether this is a good practice, and if not, then what is the way, what is the solution to this type of problem where the highest court of the land, maybe for good reasons, is forced to exercise original jurisdiction in judicial matters and also for purposes of supervising investigations?
Okay, I mean that's before Mohan. Before I come, I think we should get Mr. Sorabjee. What would you like to react to that immediately?
Yeah, but I don't know exactly. The whole question is if there's investigation, if there's prima facie evidence, these accounts are tainted, so to speak, the monies are there, are ill-gotten gains, then there's no problem.
Absolutely.
But how do you pass a blanket order?
Exactly.
What about those who have opened accounts in conformity with the law?
Whether
That's the whole point.
Whether
how
this,
do you do that?
Whether the
only saving grace is that we won't...
Yeah, please.
Sorry?
Yeah, please. What is the saving grace, sir?
You are asking me? Saving grace is the Supreme Court has said we won't release the names and has handed over the function to the SIT.
Okay.
But that really, legally speaking, I mean, that's only a saving grace.
It is a saving grace.
I don't think
actually, sir,
any court would issue a direction or a mandamus which would require the other party to breach any legal obligation. And treaty obligation is a legal obligation voluntarily undertaken by the government.
Okay. Mohan, there are several questions which have been which will come up now after what we have heard from all the other three panelists. The question now is, it has been handed over to the SIT, and the SIT is expected to investigate these matters. These are, whose original jurisdiction is this to investigate these kind of issues?
I don't know the legal aspects of this.
No, but as far as the finance ministry is concerned, there is, when these kind of things come before the finance ministry, what do they do normally?
But you see, the agreement says that you can only use the names and details of the accounts as evidence in a prosecution. Okay. Now, the SIT can't go on a fishing expedition.
Exactly.
Okay? SIT has to have a very clear case against somebody and then say, okay, this is the supporting evidence to that there's money in racketeering, money in criminality, and this is where it's been parked. And draw the relationship and show it to a court where the case is being prosecuted. Now, I think something here worries me, is that I think the Supreme Court asking for this list has got the government off the hook. This was a party which made a noise before the election saying that within 100 days we'll bring all the names and disclose everything. And that there's no obligation.
Not just name, the money also.
Not only the money, everything, and there's no obligation of any kind. Now they're suddenly in power, and now they are discovering all these obligations which are there. And now they're scrambling. I think the court came to their rescue, really, by saying, okay, give it to us and we'll keep it. Now they can say, we've given it to the court. Now it is the court to look after it. Now, I think that smells a bit to me, because, in India, all these things are possible. Okay. The other thing is that you just can't, people are allowed to hold accounts abroad legally. A lot of people in that list could be
legitimate
account holders. You just can't throw them all to
there seems to be a, this is what is interesting is that there seems to be some kind of a hint given by the Attorney General that all these may be actually illegal accounts. Sir, Mr. Shashank, there is this feeling that all these may be illegal accounts, but at the same time, the Attorney General has told a newspaper that when the list was last released in April 2014, Germany had objected to it, and more countries will object to it. And in the context of what has happened, you think that this is a concern which we should take seriously, or if these are all accounts which are supposed to be illegal, then there should be no problem.
No, here the point is what is the exact language of the agreement, treaty reached between Germany and India.
Right.
Because in all matters of fraud, actually it is a question of dual criminality. If that particular action is regarded as a fraud in the other country also,
right,
then they would cooperate with you fully. And under the new UN convention, UN resolution, which was passed in 2005, they have now come down more strictly on people putting their money in third countries. Now, as far as I can see that some of these accounts which are in Liechtenstein, I don't think why there should be an objection on the accounts, and why should they be legal? Because I do not know whether it's legally permitted to keep accounts in third countries. So obviously there is some kind of a doubt that if, let's say, you are legally repatriating money for a legal export or import requirement or local investments, then why keep the money in a third country? So that there is, prima facie, there is a possibility that this needs to be investigated, and that's for the courts to decide whether they want to look into these aspects by themselves or they want to leave it to the government departments to take care of it.
I think every Indian citizen is
Actually,
allowed.
it's a suspicion.
No, every Indian citizen by law today is allowed to take out $200,000 a year to buy property abroad. So you're going to take it to a bank, and you can't stipulate which bank. You can't say State Bank of India, branch London or branch Cayman Islands. They take you to whatever bank they want. So, there are legal accounts abroad. You can't say holding money abroad is illegal. And why should they hold money abroad? That age and period has gone. We are in a more liberalized setup where people are allowed to hold foreign accounts.
Mr. Sorabjee? Sorabjee, you wanted to intervene.
Yes. No, I said there's only a suspicion that why do you go to third countries and invest money there? Do you get better rate of return on fixed deposits? So there is a suspicion that there is some garbar.
Okay.
And because of that, as I told you, it's a very complex issue. But the Supreme Court has taken extraordinary order, and I think it was required in the present circumstances.
Absolutely, Mr.
Otherwise,
Sorabjee.
they won't make any headway at all.
No, Mr. Sorabjee, the question...
Fortunately,
sorry, Mr. Sorabjee.
Let me complete.
Okay.
The Supreme Court has given an assurance that the names won't be made public. Now, that goes a long way.
No, but Mr. Sorabjee, the basic question remains that is this some kind of a judicial overreach as far as the orders are concerned? Is it encroaching into the executives executives treaty making powers or whatever it is?
Well, not intruding, but the court has not paid, if I may say so, sufficient regard to the treaty obligations. But look, I'd like my fellow panelists to consider one thing. Forget legality. If you go about this way, which government in future will cooperate with you and give you information? And if you don't have information, how will you proceed? So the whole thing has to be tackled in a very practical, pragmatic manner. Because it's not correct that every account holder is a tainted account. Therefore, in this case, there should be prima facie evidence that this account has been in breach, but not of a blanket sort of idea that all accounts are tainted and therefore the name should be revealed. Because revealing the names is all very well to say why should a person be concerned if it's all right. It definitely affects the reputation of the person. By the time he makes over his case, his reputation is gone. It's a very serious charge.
Right.
I think Supreme Court has rather been anxious, really, to see that there is no selective giving of names. That, I think, was the concern of the Supreme Court. Don't give it selectively.
Yes, there was this concern. There was this concern expressed by many people, including political parties and leaders, that there has been selective leaking or selective way in which this whole list has been treated. Mr. Vasudev, my question is this. There are several departments, the Enforcement Directorate, the DRI, the Income Tax Authorities. These are the organizations which normally deal with these kind of cases. Now that the SIT has been given this task of looking into this, what happens to these organizations? Do they have a role or don't they have a role in this?
You know, the basic point which I think you had raised a short while ago about the role of the judiciary and the executive, all these functions, whether it's entering into international treaties, international agreements are concerned, investigating authorities like the Enforcement Directorate or the Income Tax Department and all, they're all executive functions, and normally it is for the executive to do all these things. But once the government agreed or acquiesced to the Supreme Court's order of setting up a SIT, which is really an executive function, and that SIT has under its purview, it's a very high-powered body, and all the enforcement directorate and the income tax and the CBI and everybody else is part of the SIT. So it is really an executive function which the SIT is going to exercise under the supervision of the Supreme Court. So in that sense, there is a considerable blurring of the turf between the executive and the judiciary. But having said that and having gone that far, there is no way one can retract now. But the point still remains, which I made in the beginning, that it needs to be, I think, discussed in what areas, in what respects the highest court of the land should be exercising original jurisdiction. Because one fundamental principle of jurisprudence is that everybody must have one right of appeal. Here, if somebody is an aggrieved party against this order of the court, where does he go?
Where does he go?
So I think these are the other issues which one needs. But there is considerable blurring of turf between executive and judiciary in this matter.
Mr. Sorabjee, would you agree with that?
Except that party can certainly, SIT is appointed by the Supreme Court, and that party can really put forward its defense of the SIT. And if it's a good defense, they'll accept it. Look, it's not a very clear-cut issue. I entirely agree with you. There are a number of points which arise, but look at it in the totality. Supreme Court exercises because main thing, the curse of black market or black money being stashed abroad, and the risk of selective leaks which would operate to the detriment of some people. That was the main concern.
Question
They may have overreached itself, frankly. You may say that. But please see it in the totality.
See, to my mind, the SIT just can't go to everybody on that list and say, where did you get this money from?
Mohan, I just want to bring to your notice this very important point which has not been properly discussed. See, apparently by the end of this month, which is just 2-3 days away, the SIT is supposed to... See, the Attorney General told the court today, or some news channels, and it has been reported, that this list was actually given to the government, to the SIT in June of this year. The SIT has already been having this list with them since June. That's what the Attorney General has said. Now that what have they been doing with this list since June is something which we don't know properly. And it may be the case that they've already looked into the list and already done some investigations into it.
I think June is not enough time.
No, 4 months.
4 months, you got 620 or 700 names to go through it. And to say who has accumulated this money through criminal activities, who's got it there with legitimate
No, but
reasons.
now they have been given time till November end, just 1 month more.
I doubt if SIT can do it even in that period. It's just outside their capability. You just need huge amounts of manpower, you need huge expenditures to find out. Then you have to first say that this man has been earning money through selling drugs or some kind of criminality, and then he's parked the money here. You just can't go and ask people, where did you get this money from?
Mr. Vasudev, prima facie, to establish prima facie, it's very interesting. This has just come out today that the SIT has been having this list since June, and apparently they will come out with the report on 220 names in the next few days. You think it would have been possible in the 4 months? Mohan Guruswamy doubts it.
But no. There is no reason to say that they have not been doing. I'm sure they are doing due diligence on the information that they have. But we can't have a system where you've got a ball-by-ball commentary of every day what they have done or not done, this is and that. It's not a cricket match that is going on. So we must give them time and give them enough secrecy and all that, because these are not things which can be discussed and displayed in the public domain. I'm sure they're doing a lot of useful work with the information that they have, and we should have the patience to wait for the outcome of their investigation. But we should not expect a ball-by-ball commentary on what they are doing.
Mr. Shashank, there is also a concern expressed about we are supposed to be signing a treaty of FACTA with the United States, and that may get hampered because of what has happened now. Do you agree with that? Do you think that should be a concern?
Well, this is an evolving situation. Initially, the double taxation avoidance agreements are for the purposes of facilitating investments, movement of professionals, etc.
Right.
And they are abiding by the tax obligations of the countries where they are working. Now, here we are getting into new areas, that is money being used for terroristic activities, money being used for drug running, money being used for small arms, imports, etc., and also for avoiding taxation in various jurisdictions by using the tax havens. So therefore, these are all new areas which are coming up, and then the Supreme Courts of different countries have to see that there is a system of natural justice and equality before law, so that they are going to examine whether the government has undertaken obligations which are over and above the requirements meant for international treaties, and they have violated their own country's their own citizens' rights in any manner or in a discriminatory manner. So I think these things are there for the Supreme Court to decide, and the US, of course, is mindful of its own domestic legislation, and you would have seen that US has never agreed to any international jurisdiction on any of the issues. Even they have not been able to sign the Law of the Sea Convention. They have not been privy to the International Court of Justice or the International Criminal Court.
Okay, Mr. Sorabjee. Mr. Sorabjee, it is very interesting. One more little point which I want to make, on which you please, think over. And the list which has been given to the government, to the Supreme Court, the entire list, apparently this is a list which is only up to 2006. And the court has said that the SIT will look into, account holders list till March 2015. What is the intention of the Supreme Court, and how long this SIT is this SIT a permanent body, will become some kind of a permanent body?
No, I know that's a rather curious part of it. But if I'm not mistaken, please correct me. I think SIT itself was asked. They want a nodal agency and they want the assistance of various departments.
Right.
It's not possible for SIT to do all these things in a short time. Not possible, even if the best will in the world, and with energy, it can't do it. But why don't you look at the larger picture? On the whole, is this not a step in the right direction? May not be an idle step, but a step in the right direction. We'll argue technicality, we'll argue jurisdiction, but look at the whole picture in the light of this scourge of people stashing their money, the ill-gotten gains, in countries where there are secrecy laws.
Absolutely.
Where there are secrecy laws.
Right. Mohan, very quickly, last words. You think that despite all these problems and, as far as jurisdictions are concerned, this is an issue with the Supreme Court is in the right direction as far as trying to get the governments and to act against this menace?
I think it's in the right direction, but there is due process.
Right.
You've got to go through that process. You just can't keep on saying that, I'll release these names and I'll breach conventions and treaties. Then you can't work in the international system. So you have to stick by that. And the question now I ask is, didn't Mr. Jaitley know this when he was in the opposition? He was a minister for 5 years before that. And in the opposition, he said, I will get this back.
Right.
Now, today as finance minister, he finds that he cannot do it. There are these treaties and conventions. He has to wriggle out. And I think the court and all is now being co-opted in this whole game to wriggle out. I think that is something which needs to be watched carefully.
So you think that all this what is happening may not get us what the government had promised that it will.
First of all, their figures of money abroad is absurd, astronomical. They're talking about $10-15 trillion.
That is a separate
ridiculous stuff.
That is a separate discussion.
Yesterday, a channel carried abnormal figures.
Yes, right.
So
that is a separate thing.
So I think we got to get realistic. I don't think the huge piles are not there in Swiss banks.
Okay. I think on that note, we completely run out of time. But this is, as Mr. Sorabjee rightly pointed out, there is a big picture where people have been stacking this ill-gotten money or well-gotten money, we don't know, in foreign banks, but that needs to be investigated and brought back. And people who have been doing this have to face the law. But how soon it can happen, whether the measures of the Supreme Court will ensure that this will all happen in the near future is something which is only left for speculation. We will wait and watch what will happen. Thanks to all my guests, Mr. Soli, Sorabjee, CM Vasudev, Shashank and Mohan Guruswamy. Please keep watching. We'll come back with another issue in Big Picture, same time tomorrow.